The first pitfall of proceeding in what would be a seemingly routine commercial transaction without counsel is just that, proceeding without an attorney anywhere in sight. There's more to a lease than just the basic terms of the rental amount, the term of the lease, when the lease expires, who is involved in the lease, whether or not there is a personal guarantee or not. There's much more to a lease that some people would just consider to be boilerplate language of the lease or provisions of the lease that just seem innocuous. There are other provisions of a lease, such as common area maintenance expenses or relocation issues, that at best could be a surprise to the client in the future, or at worst, a financial detriment to the client in the short term. A second pitfall of proceeding through a commercial lease transaction without counsel is assuming that the execution of the lease document itself is just a boilerplate scenario or just a mere formality of finalizing the agreement between the landlord and the tenant. However, there are provisions within a lease agreement that may seem to be innocuous to a landlord or even routine, but for a tenant, the aspects of the provision itself are vital to the tenant's success as a business. One example is the calculation of what are called common area maintenance charges, or CAM charges as they are known. In such a provision, which is a routine provision within a lease, a landlord expects to pass along the cost of common area maintenance charges to the building in which the lease premises are located, to pass those charges on to the tenant. Now, such a provision, again, is a routine provision. However, the components of the provision may be vital to the tenant itself. One example is whether or not landlords' books are audited through the course of calculation of the common area maintenance charges themselves. Another subcategory would be what costs themselves are considered common area maintenance charges. Now, we can go on for another hour and talk about common area maintenance charges and what's involved. However, the important part here is these are provisions that are open to negotiation between the parties, and sometimes tenants see them as just boilerplate scenarios. However, there's a whole world within the provision itself that is negotiable and can be discussed between the landlord and the tenant, and had the tenant not known that, then the tenant would find themselves to be in a rather precarious position in the future. A third pitfall of proceeding with a commercial lease transaction without an attorney around is assuming the fact that there may not be an attorney on the other side. Although tenants oftentimes will deal with the landlord themselves or even their agents, such as realtors, the assumption may often be made that if an attorney is not present, an attorney is not involved. However, most times when a landlord is executing a lease, there is an attorney involved on the other side. They just may not be visible. And although the attorney is not there, and even if they're not there for that particular transaction, an attorney has been utilized in the drafting and preparation of the lease agreement itself. Proceeding without counsel on your side, even though counsel for the tenant side doesn't have to be visible, it is a pitfall when you don't have counsel on your side working with you to negotiate the vital elements of your lease agreement. A fourth pitfall of proceeding through a commercial lease transaction without counsel is assuming that a lot of the provisions that mean a lot to a tenant are not open to negotiation, when in fact many of the provisions within a lease outside of just the basic terms, as we talked about earlier, such as the amount of the rental rate, the lease term itself, other provisions are indeed open to negotiation. And oftentimes, negotiations between the landlord and the tenant themselves will stall because there are certain provisions that a tenant insists on having within a lease agreement, and a landlord just doesn't want to have such a provision within the agreement itself. When counsel is involved in such scenarios, oftentimes a simple 5-minute call between counsel for the landlord and with the tenant can resolve such scenarios. However, when counsel is not involved in such a commercial lease transaction, oftentimes tenants find themselves at a disadvantage when it comes to negotiations themselves and feel like the landlord can take the approach of, well, it's either that or we don't do the lease itself. When counsel is involved, counsel will oftentimes know which provisions you can take to the landlord and negotiate and which provisions can be negotiable in that respect. The fifth pitfall is that nagging feeling of uncertainty. Was this a fair deal? Am I protected under my lease? Are common questions when an attorney is not involved. Starting a business is one of the most important decisions in one's life. Executing a commercial lease agreement is one of the biggest financial obligations that a startup business is going to face. Having an attorney there on your side, even just to review the lease agreement or enter into the negotiations with the other side, is a priceless investment for the tenant starting their own business. Thank you for listening to this video. If you have any questions, please feel free to contact me at any time or any of the attorneys here at Protorae Law for any business needs that you may have.